So in our first videos, we talked about DWIs and kind of all the legalities around when you get pulled over. But let's say you get pulled over and now you're being arrested. Let's talk about the run through of what happens once they decide that they're going to arrest you.
I think procedure, it doesn't sound like the best topic, but it's a topic that I do really like because a couple things are supposed to happen. And for one, procedure is not always followed. We are dealing with town courts where many of the judges are not lawyers and don't always do it correctly. But with that being said, procedure can be a good thing because you should know what to expect procedurally. And there's a lot of opportunity with procedure to have mistakes happen either by the DA's office or the police or whomever, where procedure itself can become a defense.
A lot of people would want to know if their license is going to be taken right at the arrest.
That can happen. It doesn't usually. I'd say the most common time that happens is as kind of I don't know if I would say as a punishment, but as a result, if somebody refuses to do the chemical test, whether that's the breath test or the blood test, the DAs have basically instructed, I think it's from the DA side, but maybe it's the police side, they've instructed that someone should be taken immediately to a judge to be arraigned and have their license revoked for the refusal immediately.
Right. Well, that goes my next question. What is arraignment and what happens there?
So basically an arraignment is your first time going in front of a judge. Someone's been charged with a crime or even a violation or a ticket, but it's the first time you go in front of the court. In some cases, that can be the day you're arrested. You're immediately brought to a judge and arraigned, and that's being told what you're charged with, being told what your rights are, those types of things. The police usually, in many circumstances, have some discretion. Do they want you to see a judge that same day, or they can give what's called an appearance ticket where they say, we're arresting you today, go to court in like 2-3 weeks.
Okay.
So many people will get an appearance ticket in a DWI case. Where we see it most commonly that they are taken to a judge right away is in the refusal situation. So they say, you're not going to do our tests. We're going to take you to see a judge today. The judge will suspend your license today.
Right.
So one other question that we were talking about was whether someone has to post a bail or not. A couple years ago, they did a bail reform and discovery reform in New York State. A lot less things require bail. Most DWI cases, there's not going to be any application for bail. It's just not what's considered a qualifying offense. But there's a couple things that can change that. If somebody is currently on parole or probation, they might be brought in for an arraignment, and they won't necessarily have bail set for this case, but they have a violation of probation or a violation of parole, which could hold them. But also there's some other circumstances, like if you're released without bail on a felony and then you are arrested for another felony, there are ways that can become a qualifying offense. But generally speaking, your average DWI, there's not going to be a requirement of bail.
Okay.
If somebody missed court 3-4 times in a row and they could prove that it was persistent and willful non-appearance, that's another circumstance where they can issue a warrant and then set some bail down the road.
So is it at the police discretion whether they want to either issue you a ticket or physically take you into custody and like bring you into the station?
It's their decision. Many of them will reach out to a district attorney and get advice on that. But I think once they've been doing this long enough, they kind of know what their office's policies are. And so like, for example, standard DWI with a breath test, they're going to give an appearance ticket almost every time. And then many of these departments say, if someone refuses, we take them for arraignment right away. I don't think that's necessarily across the board, but it's a strong majority of departments that do it that way.
So we've made it through the arrest aspect. Now it's the court appearance. What should people expect? And also talking about kind of a not guilty plea.
Sure.
When you have an attorney, your attorney is always saying you're not guilty in the beginning, or?
Yeah, and that's always is always a scary word for the lawyers. So, mostly, usually, almost all the time. So there are cases where even prior to a first court date, and this doesn't happen a ton, but we find out about the arrest, we're hired, we work really quickly, and there are times that even at a first court appearance, we're walking in and getting a deal done on the very first court appearance. It doesn't happen all that often, but it does happen. But even if you're walking into court for the very first time and you're going to be taking a deal and pleading guilty to something, even if it's a reduction or a violation, during the arraignment piece, it is like automatic. Your client's been charged with this, and I say, Judge, I'll waive a further reading of the charges, enter a not guilty plea on my client's behalf. Even if 30 seconds later we're going to plead guilty, you start it procedurally with not guilty.
Okay. So, and then there's other aspects like the investigation and discovery and negotiations, because I think, like you talk about it, where it can happen very quickly, but there's other times where, some of our cases last a year or longer. Right. And what makes it drag out longer? Sure.
That's a great question. I guess the flow of information is a really important piece to the timeline. Someone gets arrested, they hire us. We're going to be sending out a letter either that day or the next day to the court saying, hey, Judge, we got hired, just confirming the court date and time. We send a second letter to the DA's office. We usually call them and say, who is handling this case? Yep. Send it directly to them so that we're getting it to the person who's handling the case and say, I've been hired as the attorney. Can you please send me all the information in the case? And when we talk about discovery, the main pieces that we're talking about is we want an arrest report, an incident report, a 911 call, body camera in these cases, and the DWI cases is probably like the biggest piece of evidence. Photographs, tow reports, all these different materials that the police would have generated, we want all of them. The information will go from the police office to the DA's office, and then we're saying, now give it all to us. So in some ways, we are waiting for that to get to us. So that can take a day, a week, a month. What the rules say is that the timeline that a DA must give it to us starts with the arraignment.
Okay.
So someone goes into court for the first time, has their arraignment. The DA's office has generally 35 days to provide those materials.
Okay.
So most of the offices are like not holding out till day 35. They're not playing a game with the timing. It's more of, have they themselves had time to look at it? And have they sat down and taken the time to send it over?
Right.
So I'll reach out and say, hey, can you please send this over? Perhaps I get it in a week. Perhaps I get it in 2 weeks. If I haven't, I usually follow up and say, please send it over. It's also not common to go to a first court date and walk in and say, hey, Judge, good morning. How you doing? We haven't received anything yet. They still have time to comply. Can we come back in a couple weeks? We can't do anything until we receive the materials.
Right.
So generally speaking, the starting point is I want to be able to review those main materials, incident report, photographs, and really the biggest piece is usually the body camera.
Let's talk about getting a conditional license. Who's allowed to get it?
There's two main licenses that people can get when they're going through this process. They're very close in idea, but there's differences. So if when you go to court, if the judge has a breath result in his or her file, and they say, Mr. King, I have a breath result in my file that says that your client was above 0.08. It says it was 0.09. They'll usually say, the law requires me to take your license. Please hand up your client's license. I will review the documentation, make sure that it's proper. But if it is proper, we're kind of stuck with them taking the license. I'll hand up the license, and I'll also hand up what's called a hardship application. So while the case is going on, the temporary license is called a hardship license. So it's supposed to only be for what's called extreme hardship, and you have to fill out a form. So you put down your client's address, work address, who lives in the household, where they may have medical appointments or school. So it's for to and from work, to and from medical appointments for yourself, members in the household, your school or your kid's school. And that's really it.
How do they know? I mean, is there, what do they call it? The lock, like breathalyzer, where do you have to like breathe into it every time to unlock the car? Like, how do they?
That is actually a post-conviction piece of the equation, that if you are found guilty of DWI or plead guilty to DWI, you have to put the breathalyzer in your vehicle. But while your case is going on, The license that you get while the case is going on is called a hardship, and there's no breathalyzer requirement. Okay. But we have to say, is there anybody in the household who can drive you to work every single day? If the answer is yes, you don't get a hardship. Is there public transportation that makes it easy? So example, you live a half mile from work, a judge could say, walk to work.
Right.
You live right on the bus line, sorry, take the bus.
Or like
you don't work,
Ubers.
you don't get to and from work.
Yeah.
So there's an application that we put in. It's usually granted. The difference is after the case is over, if someone pleads guilty or is found guilty of DWI or driving while impaired, they can seek a conditional license. Similar to a hardship, but this one, instead of being through the court, is through the DMV. So someone goes down to the DMV and says, I'd like to sign up for a conditional license. That would get them to and from work, medical appointments, school. And then different than a hardship, there you can select 1 day a week to go wherever you want to go.
Okay.
So they give you a block of like 4 hours or something like that. And at least in my view, that's so that you can go to the grocery store, go to the laundromat, go visit your mother.
Yeah.
And it gives you a little bit of time to do some things that you need to do.
So let's talk about there's no negotiation and you're going to trial. What does something like that look like? And what's the difference between a jury trial and a bench trial? Do they even do jury trials for DWIs?
Sure. Yeah, we do both. I guess it depends. There isn't necessarily a rule of when you would do one or the other. I think what I would do is I would look at the case that I'm handling and say, what would be the advantages and disadvantages of doing a bench trial, which is a trial just in front of the judge. The judge decides what all the rules of the law is and also decides all the facts. So the judge is going to decide everything. Or you can do a jury. If it's a misdemeanor, there's 6 jurors. If there's a felony, then it would be 12. The benefit of doing a jury trial can be the jury has to be unanimous either direction. So you're going to have, say, for example, in the misdemeanor, 6 individuals are going to have to find your client guilty, or 6 are going to have to find them not guilty. So I think in some ways you can see that there might be like strength in numbers, that if we can convince a couple people that we're right, we have a chance there. But a judge, it's kind of all or nothing. A lot of times it falls back on what we know or don't know about the judges. If we think we have a really fair judge or a really good judge or a defense-friendly judge or someone who understands these issues, or if we have a judge that we think is like always leaning to the police side. If we think we have a judge that's going to find us guilty even if we shouldn't, we're not going to do a bench trial. We're going to do a jury trial, and we're going to trust the members of the community to do the right thing. But there are circumstances where we say we think there's a real legal issue in the case, and we're confident that the judge is going to see the legal issue in the case. So let's do a bench trial, and I think the judge is going to side with us. So we do it both ways.
So it's strategic. Everything you do in every case is always strategy and case specific. You can't really cookie cutter any case. Every case is different.
It's definitely something that we think long and hard about, and talk to our clients about. Like, hey, here's our options. Here's what I'm thinking and why. What do you think?
Right.
And, we wanna bring them in on that decision, definitely. We think long and hard about that. It's a big one.
My last question with this would be, which I should have asked earlier, was the difference between a suspended and revoked license.
Sure.
Is there a difference?
There is. So somebody's license is suspended if the result of their case is driving while ability impaired, which is the reduction from driving while intoxicated. And it's suspended for 90 days. Basically, at the end of the 90 days, it gets like reinstated pretty easily on the DMV side. If somebody is convicted of driving while intoxicated or aggravated driving while intoxicated, their license is revoked. So if it's a regular DWI, it's revoked for 6 months. If it's an aggravated DWI, it's revoked for a year. And basically a way of thinking about it is you're just going to have to like reapply and jump through hoops to get your license back. So the suspension is better because it's shorter and it's just easier to get your license back.
Right.
Revocation is longer, and there's a couple more hoops to jump through.
Is it true that it's costly to go through a DWI, whether you're charged with it or not? Like there are a lot of fees associated with a DWI.
Yeah, I can give you there's probably even more than I'll even think of, but hiring a lawyer, potentially missing work to go to court, traveling to court. And if you're found guilty, the court's going to assess fines and surcharges. The DMV is going to send you what's called an assessment fee, having to pay to put a breathalyzer in the car, pay to have it calibrated, pay a monthly fee.
Right. Your
insurance could go up.
Yeah.
The list goes on. It's thousands and thousands of dollars. Impound fee, towing fees.
Right.
I mean, there can be.
And those aren't usually negotiated within the court. So, I mean, those are things that you're going to have to pay.
The things that are potentially negotiated is usually just fine and surcharge. Occasionally, if somebody doesn't have much ability to pay on the breathalyzer fees, they can be lowered to some degree, but you have to put in a lot of paperwork and you have to be pretty low income to get help there.
So what is the ignition interlock device? Like, do you know how it works or?
Yeah. If somebody is convicted of driving while intoxicated, they're going to be required to put a breathalyzer in the car. The court will say that it's required to go in for a year, but you're allowed to ask for its removal after 6 months. Most courts, if there hasn't been issues, will let it come out at the 6-month mark, but it doesn't always go that quickly. There's shops in the area that you can call and ask if they install the breathalyzer units, and they'll find some that do. It costs a few $100s to have it put in, and then there's a monthly fee of approximately $100, and so it can add up if it's in there for 6 to 12 months.
My question following up that, what if the vehicle is a shared vehicle? Because I know there's a lot of families that have only one vehicle between multiple people, especially when you've got teenagers that are just getting their license and they don't have enough for their own vehicle yet.
Great question. So the way it kind of reads and the way most courts enforce it is you have to put the breathalyzer in any car that you own or operate. So generally what they're looking at is what's titled to you. So one, if you want to drive and you drive your parents' vehicle, you would designate the car that's not yours, but that you're going to put it in. Where it gets tricky is there's some people, not me, but there's some people who own 4 or 5 cars. I hope to someday, but there's some people who own 4 or 5 cars. Technically, they would have to install it on all of those cars.
Oh, okay.
So you would put breathalyzers in 5 vehicles. That gets to be a tricky point. And so we have a conversation of, do you want to sell 3 or 4 of those cars? Do you want to transfer title? If you have a father or brother who the car's paid, you can, it's perfectly legal to title it over to your brother and then a year later title it over back. I don't know if there's transfer fees or taxes or other issues, but they're going to run a background on your name and on your license information, and any vehicle that you have title to, they're going to make you put it in that vehicle. Occasionally, if there's some really unique circumstance, you can go in front of the judge and say, Judge, it's a vintage 1950 Corvette that doesn't even run. It doesn't get driven. It's a collector. And if you turned the key, it wouldn't even work. Can we swear up and down that we will not drive that vehicle? And will you let us not put it in there? You usually can work something out in that situation.
Yeah.
But
how do you know if there are multiple people driving that car that it's actually the person blowing into the system to unlock it?
There's a camera.
Okay.
Basically, it's monitored by someone, usually from probation department. So usually someone's not necessarily on probation, but they need someone to keep track of this.
Yeah.
So somehow they pay probation to monitor this. If somebody blows in the breathalyzer and it is positive for alcohol, that's going to trigger a notification that will go to a probation officer who will then notify the court of the issue. But when they get that notification that there was a positive breath reading, they're going to go look at the camera to see
what it
was it him or somebody else. So
if
you have a breathalyzer in your car, someone else can drive your car. You can let them borrow it. Before it to work, they're going to have to blow in it.
Yeah.
And
you can't get in the car then after the fact and drive the vehicle. Right. Yeah, that's what I was wondering, how they intercept that.
The conversation that I have with clients is someone else can drive your car, no problem. You can't get accused of someone else blowing into it and then you taking off,
Right.
like to avoid detection.
Yeah.
Or the passenger blowing into it and then you driving.
Yeah.
And you can't get accused of any type of tampering. So don't cover up the camera or,
Right.
you know, don't.
That's probably a violation, and then you're going to end up in court again.
Right. Exactly.
Yeah. All right. Well, thanks for answering all those questions.
You're welcome.
Yeah.